to welcome you all here tonight to tonight's Roundtable event. Tonight is jointly sponsored by eLaw, Lawyers Weekly, and my company, which is Experts Direct. For those of you who don't know, Experts Direct provides expert witnesses for litigation. Lawyers Weekly is one of Australia's leading legal publications, and eLaw is leaders in digital evidence. I'd like to introduce our chairperson of the panel tonight, which is the Honourable Justice Kevin Lindgren. Dr. Lindgren was made an Order of Australia in the Australian Day Honours List in 2012 in recognition of his service to the judiciary and administration of justice through the Federal Court of Australia and to the legal education in the area of commercial law.
Can I just tell you a little bit about the panel? John Emmering on my right is a senior partner in the global disputes practice of the international law firm Jones Day. He leads its class action practice and major claims work in the Australian region. John is a defence-side class action specialist who has advised on a large array of class action issues over the last 20 or more years, mainly in the Australian class action context, but also with some US or global connections, spanning shareholder claims, structured financial products, government claims, environmental impact, and product liability. Ben Slade is the managing principal of Maurice Blackburn's New South Wales practice and head of the New South Wales class actions team. Some of Ben's significant class actions include a shareholder class action against the AWB, settled in March 2010 for $39.5 million, the fourth largest settlement achieved to that date in a shareholder class action. A class action against Amcor and Beezy for over 1,600 businesses claiming compensation for victims of Australia's largest price-fixing cartel. Alison Stanfield of eLaw on my far right is an expert and pioneer in the field of digital evidence. She was one of the first to recognise the analysis of electronic filing vis-à-vis hard copy as the way of the future in the legal profession and court litigation. She thought that almost all evidence is created digitally, and yet existing court rules on evidence applied to paper documents only. For the past 15 years, she has built an expertise in electronic discovery, computer forensics and electronic trials as founder and CEO of eLaw. John Walker is very known as a speaker at gatherings of this kind. John is Executive Director of Bentham IMF Limited and is based in the Sydney office. John's educational qualifications include a Bachelor of Laws from Sydney University in 1985, together with a BCom from Melbourne, with majors in accounting, economics and commercial law. With over 10 years prior experience in commercial litigation, John has developed highly specialised skills over the last 10 years in providing funding for and managing insolvency, commercial and multi-party litigation. Justin Wheeling, on my far left, has been the editor of Lawyers Weekly magazine since June 2011. In that period, he has helped to establish Lawyers Weekly as Australia's leading online legal publication. As a legal journalist, Justin has broken many of the most important stories affecting the legal profession over the past few years, including the arrival of Clifford Chance in Australia, the plans of Vincent Masons to launch an Australian practice, and the launch of best practice guidelines for the legal profession by the Christian Jepson Memorial Foundation in May last year. From a defendant's perspective, what are the major reforms of the class action regime that you would like to see happen? Sure.
Break it down into three areas. The first area would be around procedure. I think there's a number of significant procedural reforms we could invoke to improve the system. I think the tests are all soft to start the actions. One of the big things we don't do well in class action litigation is define the common questions with sufficient clarity and in a meaningful way. So procedure, substantive, and the other area which we don't talk a lot about, but we should, is execution. And we have a practice note, CN17 in the Federal Court, which Kevin Lindgren, he's dropping me into things, he actually wrote this practice note, which counsels the early engagement between the parties to clarify issues, to talk about the scope of discovery, to really wrestle with those things at an early stage.
Federal Court's practice note says that on the first directions hearing there will be a case management conference, and yet that's never happened in any of the cases that I've commenced. And look, there aren't that many cases we commence. It's one of the 30s that's been going around from the US Chamber of Commerce that there's this enormous explosion in class actions and they're happening everywhere. Well, it's just not true. There aren't that many, but look, admittedly, me and my mates are running most of them, and when we start them, we don't get a case management conference first up. We tend not to get it second up. After about a year and a half of really irritating interlocutory skirmishing, we plead for a case management conference and then get a thing that's organised with transcription, and it is a bit more informal. We've had a couple relatively recently, and it is definitely the way forward, I think.
For me, that's the biggest problem and the biggest issue to get across in these early conferences. Obviously, the plaintiffs want to get to the key records as quickly as possible, and they assume you have a file set on the shelf that says knowledge of misleading conduct. Here's all our file minutes in relation to confused disclosure. Okay, thank you for that. I'll come back to that. And of course, as you know, the problem with these knowledge-based cases is the knowledge is fragmented, and the case theory often tries to pick up someone's knowledge here, and this person over here, and this person over here, and you add it all together, and you get corporate knowledge, the corporate mind.
We've had a circumstance where 20% or 3 of the last 15 of our class actions haven't involved the civil justice system. So in excess of $100 million has been paid by defendants without bothering the court. And this was achieved exactly in the way that's been spoken of, that you have informal disclosure of relevant information to either parties. Clearly it can't settle until there is that swapping of information. And if you have plaintiffs who are well advised and properly represented and clearly cannot settle claims unless they know enough about the value of their causes of action, and also defendants who are prepared to accept that there could be some wrongdoing, God forbid, then both parties can swap information, work out whether or not litigation is necessary.
How does the use of technology during the discovery process increase efficiency, decrease cost, and add value to the preparation of the party's case? In particular, have class action lawyers embraced technology, and how do you see technology assisting in class actions?
Thanks, Judge. Yeah, obviously I think technology really comes to the fore during discovery, particularly when you have a large number of documents, and as we all know, almost all evidence today is created electronically. So the days of the nice manila folder, as John said, with everything in it, is long gone.
It's never there.
That's not quite.
These days, when lawyers ask their clients for anything that's relevant, you might get a blank book. But then it'll be, well, we have emails and we have stuff on a file server somewhere. If you're lucky, they may have a document management system. But what we find is that generally the evidence is spread across a large number of places. So the first port of call is to say, well, where is the evidence? And then we can narrow that down with questions such as, what's the date ranges that are relevant? Who are the relevant people involved? And so the evidence collection becomes more of a corralling exercise. The next step in the process obviously is to then, try and just get the documents into a repository that are, potentially relevant, and then work with the legal team to identify, those that potentially will make their way into evidence down the track. So the technology is improving all the time. I've been doing this a long time, and in the old days, when evidence was still predominantly hard copy, it was scanning and data coding documents. Now, as I said, it's all about obtaining electronic evidence in the first place, and you can really use the technology to use the power of the content in those electronic records. And what I mean by that is, as I said before, dates, so that you can filter on date ranges, but also searches. And I'm sure you'll know the power of a keyword search. But a keyword search can be somewhat limiting. You can get more than what you're looking for, or you may miss things because you don't know what you're looking for. And technology really helps if you don't know what you're looking for. And the technologies that we're looking at today analyse every word in every document, and then it can assist by throwing up, I guess, pools of documents that are of like concept or a similar subject. To give you an example, we use a demo case that uses the Enron data set. And so if we put to the data set a term such as fraud, it will come up with Arthur Anderson or off the books. But it will also, if you look a bit more closely in the terms that are thrown back, it comes up with a number of Star Wars characters, which was some project names that were given in some of these things. So if you don't know what you're looking for, you may see Project Jedi and wonder what that's about. And if you actually go in and actually review some of the documents which have been corralled together, that may lead you down a train of inquiry, potentially, which you haven't considered before. So the benefits of the technology are that it allows lawyers to, I guess, cut to the chase a lot more quickly. It means that, if you don't know what you're looking for, you can, again, cut to the chase more quickly. It brings documents that are similar together so that your review is done much more in a much more targeted way, so you can get senior people looking at potentially relevant documents straight away and leave the potentially not relevant documents down the track or to more junior people. So when you compare that to the old days of paralegals sitting there and going through documents one by one, you can see the time savings there. I think the major benefit, though, is once you've done that review and analysis and, as John mentioned before, you may have to try and piece together the evidence. So, one person might be doing one thing and another person's doing another thing, and then you've got, documents that go to prove a number of different things. Well, the power of the technology comes into the fore again there by allowing you to cross-reference the workflow. So, for example, we've got a case at the moment where there's many companies, many payments, many invoices, many bank statements, and they all have to be, the lawyers have to review those and put them against companies, payments and so on. But if you can imagine having to do that in hard copy, you'd have to have numerous copies of everything. Different colour schemes, different post-it notes, and it would, it can be a nightmare. The technology makes all of that really easy, and you can, again, see the cost savings there by really saving a lot of time. And I think it really allows you to get on top of your case much more quickly and much more effectively.
I'll be keen to see others share this view in their experience. The technology is fantastic, but with all of the stories, when I first started, a big case was an office full of papers. Then the next generation big case would have been a room half this size and a room this size, and HOH came along and all the papers laid side by side on HOH. If you've done that, ran for 45 kilometres. I mean, who can read this? Another recent one, 2.5 million records. I mean, these are impossible numbers, and technology and the complex searching that can be done now to try and filter and get to things. In some ways, it's actually given us a reason not to tackle the problem, because we're finding ways to make it possible to access all this electronic material. It just seems to me some of the solutions around need to be worked on a bit more. One solution is don't give discovery. We've seen that in the equity division in Sydney. That's an extreme solution. defendants kind of like that usually. But there's a lot more, it seems to me, that could be done around that issue. There's just been a lot more attention around the discovery stage of it.
One of the problems with discovery is both parties have to explain the issues in dispute to their lawyers, and the lawyers have to understand all of the facts and circumstances to work out what's relevant to the issues in dispute. So you have all of these people who weren't involved in the original creation of the issues that are being addressed in the process, who are trying to work out how do we deal with it. And perhaps I'm inviting not, obviously, any mass reform in the civil justice system, but a way of potentially taking out the adversarial process involved in discovery and trying to have onuses or obligations which are perhaps more efficient than this fishing expedition and this, I have to go and trawl the ocean for all these documents. That's clearly in no one's interest.
I'm a big believer in the concept that we probably need to make more cost orders against the plaintiff in relation to discovery in that. let me finish. In that, I think there's a reasonable degree of discovery that can be requested. More often than not, because there's no real, they say yes, we have to go through the records, but there's no real sense of the penalty is felt by the defendants. I'd like to see the courts framing some reasonable budget for discovery and then saying everything beyond that is paid for by the plaintiff.
If you were to draw discovery orders in a more objective way, say specific date ranges, people, departments, document types, for people like myself and Alison, it makes it a lot easier to go off and collect and review that stuff, and therefore a lot cheaper than the subjective requests that are made that are essentially a fishing exercise. So my question is really, could we draw discovery requests and categories in a much more objective way? And in my view, that would certainly reduce the burden and reduce the cost.
There are other options. John's mentioned the possibility of deposing company executives to identify how the documents are sorted out and therefore enable us to get the categories clearly identified. But also we should, I think in some circumstances, have opportunities where independent court-appointed experts can be enabled to go into the company and to search the databases information to come out with documents that do those things, understand discovery, rather than just relying on the defendant to do it. And there may be some cost shifting there. I'm not enormously excited about cost shifting, of course, because it means shifting onto my side of the transaction, but there are some circumstances where cost shifting may have to be accepted by us.
There are documents identified that are relevant and really critical to the case. Then the technology is such that you can throw it back out to the data set and say, well, show me any other documents that are like this. And that saves an enormous amount of time. And so if you can find those critical elements and then say, well, what's the pool we're looking for here, that can really come to the fore as well.
We've got a couple of very modest panel members here. There's been a bit of discussion tonight about what's happening in the area and the club. People who are practicing in class actions, but of course there are plenty of other people who are getting exposure to class actions either as potential plaintiffs' lawyers or defendants' lawyers. I've chaired the Law Council's Federal Court Liaison Committee now for nearly 20 years, and I'm very proud of the fact that that work that's been done by people like Ben and John and other members of the committee has culminated in a thing called the Federal Court Case Management Handbook, which received the imprimatur of the Chief Justice 2 years ago when it was launched, and tries to bring together best practice and procedure commentary in the federal court. It's not a substitute for books that look at rules, and it's not a substitute for books that deal with substantive law. But the chapter that is about to be launched, and which was workshopped with the court last year, and is now with the editorial committee that comprises Kevin Lindgren, John Sheehan, and Simon Daly.
Would you please just join with me in thanking our panel members, all of them, for the great contribution that they've made tonight. They're all very competent in this area, and I think that they've really treated us very well. Join me in thanking